There's at least three misconceptions that many people have about patent mediation. Number one, that mediation is binding, which it isn't. It often gets confused with arbitration. Secondly, that you have to complete all your discovery in a case before you go into mediation, which is not necessary. And the third thing is that initiating mediation is a sign of weakness, that anybody who suggests it is indicating that they don't have any confidence in their case. Those are three common misconceptions which we're hoping to overcome. Patent litigation is so expensive, and corporate budgets are under siege. So I think in-house counsel are probably going to be giving some serious thought to using the process more than they have in the past. I mean, patent litigation can run anywhere from $3 to $5 million. Mediation is substantially cheaper than that and can be done for anywhere from $50,000 to $100,000. And depending on when you do it in the cycle of the case, the less you're going to have to spend on litigation. One of the great advantages of mediation is that you get a result, you get an answer. It's an answer that you've negotiated with the other side, but it eliminates the uncertainty that litigation brings with it. One of the things that companies that own patents may want to do is they may want a court to decide whether a patent is valid or invalid. And in a mediation context, it's going to be a negotiated settlement. There's not going to be a court ruling that the patent is valid or invalid, and therefore you can't use that as precedent with respect to other potential infringers. However, there's a lot of danger inherent in wanting such a ruling because it could go either way. And so when you decide to sue an infringer as a patentee, you are putting your patent at risk. But you don't get a precedential opinion through the mediation process, and some people want that. A critical factor for both the mediator and the parties is patience. This is not something that happens right away. A typical life cycle of a mediation is 2 to 3 days, and there's no harm in doing it more than once. And several clients have reported to us that they've had great success maybe on the second go-round or the third go-round. What often happens in mediation, which never happens in litigation, is that the parties often find business solutions, particularly if you're having two companies that are in the same industry. I mean, one company could say, okay, I'll take a license from you, but you have to agree, Mr. Patentee, to agree to have me supply you with certain products. In a mediation, one that's properly handled and one that's successful, obviously, both the parties and the mediator try to come up with business solutions. And that's why it's so important to get the decision makers at the mediation itself. And it's also important to have a mediator who is not just shuttling between caucus rooms and presenting numbers to each of the parties, but actually tries to learn as much as he or she can about the business and then coming up with, in some cases, their own solution to solve the problem.